Welcome to Risk Engineers Talk Governance. In this episode, due diligence engineers Richard Robinson and Gaye Francis revisit the topic of due diligence, and this is thanks to an email from Chris. And they wrote that they've been listening to the podcast to better understand risk, due diligence, rail safety, national law, and duties of engineers, and that it's hard to rationalise the relationship and hierarchy of rail safety national law versus Victoria's OHS Act, what it is and isn't required to be diligent, and the relationship of risk assurance and diligence. We hope you enjoy their chat. If you do, please give us a rating and subscribe on your favourite podcast platform. And if you'd like more information on R2A's work or have any feedback or topic ideas, do what Chris did and head to r2a.com.au.
Hi, Richard. Welcome to a podcast session.
Good to be here again, Gaye.
It is. Today we're going to revisit due diligence, and part of it's based that we've recently had an inquiry about an observation, I guess, that there's some confusion and differing views out and about around the risk space, around risk and assurance and diligence and what it actually means. And I thought what we do today, we've covered due diligence on a number of our podcasts, but if we go back today and have a look how we actually started in the due diligence, I guess, space, engineering due diligence space, and why we did it, and how we apply due diligence in the engineering work that we do, that might be a useful conversation. So I'll get you to give an intro into how we became due diligence engineers.
I can do that, although I must firstly observe it was a surprise to me to see that you'd never actually listened to one of our podcasts. I recommend you do that, Gaye.
Oh, we're only in season 5, Richard. I'll get around to it.
Excellent. Now, anyway, the reason why we became due diligence engineers, as far as I know, you were around during the entire process, was that we were doing as a response to expert witness matters before the courts. Now, we're engineers, not lawyers, so what happened was that every time you do an expert witness case, the lawyers tell you to read various things, and they directed our attention to various relevant cases, particularly Wyong Shire Council versus Shirt, where Chief Justice Harry Gibbs, talking about the balance of the significance of the risk versus the effort required to reduce it. But what became patently clear to us about all of this was that due diligence has always been a defence against negligence, and there were two parts against the defence against negligence. The first part was the no power defence, that you could only be responsible for matters over which you had control. And the second part was that in the circumstances, as a reasonable human being, you would do all reasonable things to protect against foreseeable bad things that might happen to other people around you or the people who you're doing, your clients and so forth. And so due diligence was articulated quite clearly to us as a defence against negligence. Now, the world moved on, and in 2004, Maxwell QC reviewed the OHS Act in Victoria, and he put in place that you had to eliminate hazards so far as reasonably practicable, and you couldn't eliminate, you had to reduce them so far as reasonably practicable. But the Victorian Act doesn't talk about due diligence anywhere. But nevertheless, we were cognizant of what the Act was talking about, and we were doing at the time, quantified risk assessment, you target levels of risk and safety around major hazard facilities. And I've got to say, it's a prosperous area of activity to be in.
It is.
But when you looked at that and you looked at what due diligence as a defence against negligence was, which engineers had to apply. I mean, you have to buy PI insurance if you're an engineer to protect the engineers, and that's mandated under registration of engineers and under the Code of Ethics of Engineers Australia if you don't happen to be a registered engineer. That you have to do these things. And we basically had to say to the major hazards regulator in Victoria and all other jurisdictions, and this includes quantified risk assessment in railways, which we had to walk away from, quantified risk assessment in the aviation sector, which we had to walk away from. We said you cannot demonstrate due diligence by using target levels of risk and safety because there's two parts to it. Apart from the difficulty of actually knowing what the number is for high consequence, low likelihood things, which is a rabbit hole which I'm about to test in a court case in the very near future in Brisbane. The other one is, the other side of the equation is what's reasonable in the human effort, because designating human effort, you can't quantify that unless you're just going to put dollars to it or something, and that doesn't work when you talk about life safety. So we had to say to the major hazards regulator in Victoria and all these other places, we're not going to do it anymore. And why aren't we going to do it anymore? Because we've given up on using target levels of risk And you have your duty is as an engineer, and your common law duty is to demonstrate due diligence. Now,
to enable to show that all reasonable
practical
practical
controls are in
precautions.
place. Now, at this point, you could have knocked us over with a feather when Julia Gillard turned up and then started promoting the WHS legislation, taking the so-far approach from Victoria, because remember, she was Victorian, well, at least for the purposes of, she went back to South Australia, but for the purpose of this, she was a Victorian. And then she became Workplace Relations Minister's, as
The chair.
the chair, as Deputy Prime Minister and so forth. And she obviously put a heart and soul on it. And she basically tucked due diligence into the WHS legislation. But quite correctly, as some people say, and as far as I know, we've always been quite crystal clear on this, that due diligence obligation, in a statutory sense, applied to the officers of the corporation. The business, the PCPU, has to demonstrate that all reasonable controls are in place. Anybody who works there, you've got to demonstrate all reasonable controls are in place.
Reasonable care.
But the due diligence obligation, and remember, due diligence only includes, it doesn't mean the 6 items in the WHS Act. And I spent a lot of time with Barry Sheriff giving presentations on behalf of Engineers Australia, all over Australia, talking about all this, because he would talk about what's required. Then I'd say, well, here's what you have to do to demonstrate due diligence with regards to how an organisation would show that all reasonable practical controls are in place. Now, at this point, seemed pretty clear to me, the due diligence provisions of the WHS legislation, the onus on directors came from the common law, due diligence as a defence against negligence. And I haven't had any lawyer ever disagree with that understanding. Not that it came from the common law, and due diligence is a defence against negligence in the common law. Now, that means from a practical viewpoint, all engineers anyway have to demonstrate due diligence.
Yeah, even though it's not explicitly said in the legislation.
Yeah, because you've got to demonstrate in the negligence anyway.
As a professional engineer.
As a professional engineer, if that's what you hold yourself out to be. And then, as the Chief of the Navy goes to some trouble to say in his documentation, anybody who works in that organisation had better help the officers demonstrate the officers' due diligence. And how do you do that? You demonstrate that all reasonable practical controls are in place. To say that the engineers don't have that duty, I just find bizarre.
Yeah, it's sort of inferred in a way, isn't it? And that's how you go about your business, you know. As an engineer, how do we show that we're not being negligent? Well, we use due diligence as the demonstration and the process.
You don't use risk assessments except as the second part. You work out what the core issues are. Because remember, we always came top down. And that's the other thing about R2A always does. We always say you must come top down working out what the credible critical issues are.
Yep.
And then you work out what the options are. And then you say in the circumstances, the balance, what's reasonable, because that's the only way you can practically do it.
Yeah. So we want to do that completeness check like we talked about, what all the controls are in that can be put in place and what is reasonable in the circumstances.
And if you want to be a worthwhile engineer and valued to the organisation, particularly if you're a young engineer starting your career, and this is something we say all the time when we're training young engineers, if you can show that whatever decision you're making has been diligent in a way that will satisfy your managing director and your board, you are worth your weight in gold. And if you are unable to do that, then you're not going to be a very successful engineer, not in this day and age.
And helps inform decisions to be made.
Correct.
So by doing it throughout the organisation, and people are right, they come and ask, and there's questions that some of the legislation or some of the regulations and hierarchy control, for example, there's some mismatch between
the regulators are muddled.
And there is some confusion out there on what the requirements are. But as we said, we've always used due diligence as a defence against negligence, and the hierarchy controls as the court sees it. So those 3: elimination, prevention, mitigation.
But it actually goes on. Remember, some people, and I've seen this written a number of places, oh, well, if the regulator says it's okay, we're good. No, but it goes badly wrong and the public prosecutor wants to have a go at you. The fact, almost all regulators, all that I've ever read, as long as they're acting in good faith, they can't be prosecuted for negligence.
Okay.
But the company can still go down.
Even though they've followed the rules
Even
of the
though
regulator.
they follow what the regulator said. Just complying. Unless your legislation for your regulator specifically says that acceptance by the regulator has satisfied all your obligations, and Most
They're
regulators
pretty
try to
clever.
avoid that.
I was going to say they're more clever than that, saying a full-on statement like that.
Well, that's not quite right, because I mean the Victorian Major Hazard Regulator says they have to accept it.
Yeah.
But that's not what all jurisdictions say in all the regulatory regimes. You want to be very cautious and have a think about exactly what it is your regulator can and cannot accept.
Comes back down to that question that we've talked about on a number of occasions, and the topic we've talked about on a number of occasions, that you have to think these things through for the circumstances that you find yourself in and the organisation in which you, and the whole of context that you're in. It's not just all of the silos, that you've got to put all of that together and have a holistic approach on this.
And relying on a standard as your core defence, you've got to think it through, and then you test against the standard to make sure you haven't overlooked anything.
True, which we covered in our podcast very, very recently.
Indeed.
So what we want to talk about today was that there is some confusion out there. There's differing views.
I suppose it's actually relevant from our point of view. Our book, Criminal Manslaughter, How Not to Do It, that's aimed at directors.
Correct.
And our latest publication, which was
Risk Management and Negligence, a guide for engineers.
Essentials for engineers,
Yep.
Due Diligence Essentials for Engineers, because one of the points you make in here, I think it's section 22, basically points out that designers have a particular duty.
Under the WHS legislation.
Correct. And that duty is to eliminate hazards so far as reasonably practicable. And how do you go about demonstrating so far as reasonably practicable that you've achieved those designer obligations? Anybody who says you don't have to do due diligence to achieve that, I think, is courageous.
Well, maybe on that note, we would just say, think about what you need to do. And as I said, we've always used due diligence as a defence against negligence in the work that we do, and we would recommend
continuing that way.
that way.
Not to change it.
So thanks for joining us today, Richard, and we will see you next time. Thanks, everyone.
Thanks, Gaye.